Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Henry Fuentes, decided on October 23, 2025. Singas, J. This appeal asks us to determine whether the people provided the discovery required by CPL 245.20(1) before filing a Certificate of Compliance, COC, and declaring their readiness for trial within the applicable speedy trial period. Specifically, we must decide whether the people's COCs were invalid because they failed to first disclose the Police Internal Affairs Bureau, IAB, report concerning misconduct allegations against the arresting officer arising from an unrelated incident. We conclude that, even assuming CPL 245.20(1) K4, requires the people to disclose such misconduct allegations, the people did so here, filed a valid COC, and timely declared their readiness for trial. Thus, we affirm, albeit on different grounds. 1. The legislature's recent criminal discovery reforms became effective on January 1, 2020, and constituted a sea change in speedy trial and discovery procedure, People v. King. They imposed new automatic disclosure requirements and tied these discovery obligations to trial readiness under CPL 30.30, quoting People v. Bay, see CPL Art 245. Under the current statutory scheme, the people must disclose enumerated materials within 20 days of arraignment when the defendant is in custody, and within 35 days of arraignment when the defendant is not in custody, see CPL 245.10, 1, A, I, 2, 245.20. After providing the required discovery, the people must file a COC averring that they have done so after exercising due diligence and rendering reasonable inquiries to locate and disclose discoverable materials. Filing a valid COC is a prerequisite to trial readiness. Thus, a court must grant a defendant's motion to dismiss on statutory speedy trial grounds if the people have not filed a valid COC and declared ready for trial within the time frame provided by CPL 30.30, 1. The materials subject to automatic discovery are listed in CPL 245.20, 1, which until August 7, 2025 provided that the prosecution shall disclose to the defendant, and permit the defendant to discover, inspect, copy, photograph and test, all items and information that relate to the subject matter of the case and are in the possession, custody or control of the prosecution or persons under the prosecution's direction or control, including but not limited to, certain enumerated materials. Paragraphs A through U then list various discoverable materials, including, as relevant here, all evidence and information, including that which is known to police or other law enforcement agencies acting on the government's behalf in the case, that tends to impeach the credibility of a testifying prosecution witness, former CPL 245.20, 1, K4. For purposes of CPL 245.20, 1, all items and information related to the prosecution of a charge in the possession of any New York State or local police or law enforcement agency shall be deemed to be in the possession of the prosecution, CPL 245.20, 2. CPL Article 245 also contains a presumption of openness, favoring disclosure when interpreting Section 245.20, 1, CPL 245.20, 7. Separate from CPL Article 245's automatic discovery obligations, due process requires the people, as articulated in Brady v. Maryland, to disclose evidence in their custody, possession, or control that is favorable to the accused, including evidence that impeaches a government witness, People v. Garrett. Impeachment evidence falls within the Brady rule because, when used effectively, it may make the difference between conviction and acquittal, id. Quoting United States v. Bagley, see also Giglio v. United States. While CPL Article 245 requires covered materials to be disclosed within 20 or 35 days after arraignment, see CPL 245.10, 1, A, 2. Due process requires Brady material to be disclosed in time to give the defendant a meaningful opportunity to use it. People v. Cortijo, see People v. Stedman. 2. Defendant was charged with misdemeanors arising out of an encounter with Suffolk County Police Officer Daniel Congito resulting in his arrest. On May 11, 2021, the People filed a COC and Statement of Readiness, SOR. The People's disclosures included a spreadsheet indicating that a lawsuit had been filed in federal court in January 2020 against Congito. The spreadsheet provided the plaintiffs' names and the lawsuit's docket number. On July 28, 2021, the People turned over a copy of the complaint and amended complaint, the docket report, and a notice of the lawsuit, and filed a supplemental COC and SOR. The amended complaint alleged that in June 2019, officers surrounded John and Francis Clemente's home with guns drawn after receiving 911 calls that John had been walking around his lawn with a gun. It further alleged that the defendant officers beat John, searched the home, and confiscated guns without probable cause, a warrant, or consent. Related to the allegations of an unlawful seizure, the complaint asserted that the defendant officers demanded that Francis sign a consent to search form only after they had searched the entire home. On January 10, 2022, prior to a Huntley/Dunaway hearing where Congito was the People's sole witness, defendant asserted that the People failed to comply with their disclosure obligations under CPL 245.20, 1, K4, because they had not provided material generated by the Suffolk County Police Department IAB regarding the incident with the Clementes. 4 days later, defense counsel demanded, by letter, any outstanding Brady/Giglio material for Congito. The letter specifically referenced the Clementes lawsuit and asked for, among other things, information as to whether the IAB had made a finding regarding the alleged misconduct that the lawsuit described. That day, the People turned over an IAB report from the Suffolk County Police Department dated April 27, 2020, an updated docket report from the federal lawsuit, a letter indicating that the lawsuit had been resolved, and a second supplemental COC. The IAB report indicated that an internal investigation was commenced based on the allegations in the federal lawsuit. The Clementes declined to be interviewed in conjunction with the investigation, and their perspective of the incident and allegations of misconduct were therefore drawn exclusively from their notice of claim and complaint. The IAB report indicated that Congito had been accused of performing an illegal search/seizure but was exonerated. Specifically, the report determined that Congito completed a permission to search form documenting that on June 13, 2019 at 2015 hours, Francis Clemente gave permission to search her premises and all property found therein. The report also summarized Congito's account of the incident. As relevant to the Clementes search and seizure claim, it stated that Francis gave written permission to search the house and wanted the police to remove the rifles from the house, and that Francis provided the key to the gun locker and opened the locker. In February 2022, defendant moved to dismiss on statutory speedy trial grounds, arguing that the People's COCs and SORs were invalid and illusory. Defendant asserted that the People were obligated to turn over all IAB records for Congito pursuant to CPL 245.20, 1, K4. Defendant also contended that the People failed to exercise due diligence and good faith in ascertaining the existence of discoverable materials and turning over such materials. District Court granted the motion, holding that the People's filing of their COC and SOR were invalid until discovery was completed when the IAB files were turned over. As such, the People had exceeded the applicable 90-day speedy trial period, see CPL 30.30, 1b. The appellate term reversed, denied defendant's motion to dismiss, reinstated the accusatory instrument, and remitted the matter to District Court for further proceedings. The court concluded that it is undisputed that the contents of the IAB files at issue here are not related to the subject matter of the case and thus, there were no IAB files here that were subject to automatic discovery. A judge of this court granted defendant leave to appeal, C 41 NY 3D 983, 2024. 3. The parties dispute which version of CPL 245.20, 1, applies to this appeal and the relevance and meaning of the statutory phrase that relate to the subject matter of the case. According to defendant, CPL 245.20, 1, K4, covers all impeachment material and encompasses the people's Brady obligations, making any COC the people filed before disclosing the IAB report invalid. The people contend that the subject matter of the case language means that before filing a COC, they must turn over any impeachment evidence in their possession arising from the instant criminal case, whereas they must turn over any other impeachment evidence in their possession in time to satisfy their Brady obligations, which are not tethered to the COC requirement. We need not resolve these questions because under either version of the statute, and even assuming that CPL 245.20, 1, requires disclosure of misconduct allegations not arising from the facts underlying the instant prosecution, the people disclose that information before filing their timely COCs. Under both versions of the statute, the people's automatic discovery obligation extends to certain material that tends to impeach a prosecution witness's credibility. We have held that misconduct allegations against law enforcement officers, when relevant to a witness's credibility, are properly the subject of cross-examination for impeachment purposes. See People v. Smith. Subject to the trial court's discretion, defendants should be permitted to ask questions based on the specific allegations of the lawsuit if the allegations are relevant to the credibility of the witness. See also People v. Rouse, Garrett. The people alerted defendant to the Clemente's misconduct allegations which we assume, without deciding, were relevant to Congedo's credibility with their timely COCs, by disclosing the docket number, complaint, amended complaint, docket report, and a notice of the Clemente's federal lawsuit. The question, then, is whether not disclosing the IAB report before filing their timely COCs rendered those COCs invalid. We conclude that, under the facts of this case, it did not. The misconduct allegations set forth in the IAB report were drawn exclusively from the federal complaint and related materials, and the Clementes were not interviewed as part of the IAB investigation. The IAB report otherwise laid out Congedo's account of a purportedly lawful search and credited that account. Defendant argues, and the dissent agrees, that the IAB report should have been turned over because it provides additional details about the incident with the Clementes beyond those in the amended complaint. But CPL 245.20, 1, K4, does not require production of a document just because it provides additional information not in other impeachment material. The question instead is whether the document tends to impeach the credibility of a testifying prosecution witness. CPL 245.20, 1, K4, C. Smith. Specific allegations that are relevant to the credibility of the law enforcement witness must be identified. See also Black's Law Dictionary, 12th edition 2024, tend, to serve, contribute, or conduct in some degree or way, to have a more or less direct bearing or effect, impeach, to discredit the veracity of, a witness. Here, the IAB report does not. Our conclusion is not based on any prejudice analysis, but on application of the relevant statutory language. The IAB report includes notes from interviews with civilian witnesses, but none of those witnesses even mention Congedo or described misconduct. As explained above, the report also contains information collected from an interview with Congedo herself recounting the events with the Clementes, including that she obtained Francis's uncoerced consent to search the home. But none of the notes from that interview which recount Congedo's unremarkable account of a lawful search would negatively impact her credibility. Finally, the dissent incorrectly describes the IAB report as specifying that the allegation against Officer Congedo concerned an illegal search/seizure. The report, like the dissent, may have surmised based on Congedo's interview that the generalized allegations in the amended complaint regarding the search and seizure likely referred to Congedo. Crucially, though, nothing in the report states that the Clementes ever identified Congedo's involvement or indicates that she engaged in any of the conduct alleged in the amended complaint. Because the IAB report did not contain any separate allegations of misconduct against Congedo nor any support for the amended complaint's allegations as they pertain to Congedo, it did not have any tendency to impeach her credibility, CPL 245.20, K4. The dissent also contends that the IAB report had to be disclosed because it contains the allegations taken from the amended complaint, which themselves had to be disclosed. The IAB report describes the amended complaint in general terms, such as alleging false arrest, unlawful search and seizure and abuse of power, and asserting that police searched John's home without consent and ordered his wife to open their gun safe. But to the extent that the dissent suggests that these allegations drawn from the amended complaint tended to impeach Congito, the people undisputedly disclosed the source and full content of those allegations before filing the timely COCS. Thus, the IAB report itself has no impeachment value. This is not a prejudice consideration. Rather, CPL 245.20, K4S tends to impeach standard inserts considerations of evidentiary value into the disclosure requirement itself. Nothing in CPL 245.20, K4, additionally requires the people to disclose every single document referencing impeachment material subject to disclosure based solely on that reference. The people's timely COCS were thus not invalid, and the appellate term properly denied defendant's motion to dismiss. Because of our conclusion, we need not reach the people's argument that they exercised due diligence in obtaining and disclosing the IAB report. Accordingly, the order of the appellate term should be affirmed.
Welcome to NYPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypt.com/law to read the full decision.